Well, hello and welcome to another Sunday Coffee with Dr. Childress. This week, it's Easter Sunday. So I am doing my uh, Sunday coffee talk on Easter. It must be an Easter sermon. So today I'm going to be discussing the holiday theme, betrayal, sacrifice, and resurrection. More specifically, I'm going to be discharging my duty to protect, or I've already done that, and I will be discussing my discharge of duty to protect to the California state licensing boards. Uh, so, but just the theme, just to address the theme of Easter here, betrayal, sacrifice, and resurrection, it seems very appropriate. The betrayal is of you, the targeted parents, and more importantly, to your children by the institutions that should protect you. That's the state licensing boards, the American Psychological Association, the psychologists individually, and all of the institutions that surround you, the judicial institution, that are undermined by the bad professional psychology services they're getting. All of them are betraying their obligations to the children and to you, the parents, to protect you from the child abuse and spousal abuse by a pathological parent. And you are being sacrificed. You are the sacrifice to their financial exploitation of you. They are basically exploiting the pathology for their own needs, but they're not solving it for the children and the parents. But we're headed into resurrection because we're going to collapse the forensic custody evaluation industry in the family courts, and we're going to begin to solve the pathology, diagnose it, and treat it. So that's the broad theme of today's discussion, is about the betrayal, institutional betrayal, the sacrifice of the children and their parents to the financial interests of the professionals, and what we're going to do about it, the resurrection that will be forthcoming in the months and years ahead. So first, though, I want to address the California Board of Psychology issues and what's going on there. If you haven't realized by now, I document things. That's what I've been doing for 15 years in the family courts, documenting things. Well, now I've got documents. It's been officially entered into the official legal record on a 3-day hearing. I got all my exhibits admitted into evidence and my testimony. And what I'm going to be doing, I will be in the days ahead, I'll be going through all those documents on Sunday coffee type talks, where I'll be describing what they are and the importance that they have for the overall situation of institutional betrayal and regulatory capture. That's Freud, F-R-E-Y-D, and Stigler for regulatory capture. And so I'll be doing that more broadly. But in terms of just the board situation itself, that was filed by a board complaint filed by doctors Burnett and Lorandos, who are self-proclaimed experts in parental alienation. And the California board found that my criticism of them damaged their professional reputations, and apparently that's unethical to damage the professional reputations of other professionals in the field. I would dispute that even now. I think there's a wonderful amicus brief that's involved that wasn't accepted, but that also addresses the issue of truth in statements and various aspects of that component. But as it stands, I've had to surrender my license. The California board put me on probation. I cannot serve probation in California when I'm living in Washington State. So I will surrender my license because I cannot fulfill the conditions of probation as long as I'm living in Washington State. I still have my Washington license, and that will be my next focus, is to stabilize that. And I think I'll be able to stabilize my Washington license relative to the ripples coming out of this situation. So I will hopefully get through this okay. And I will just not criticize Doctors Burnett or Lorandos or any of the parental alienation self-proclaimed experts about anything they do. So that's up to you. Everybody knows my opinion about their professional practices and moral character, and I'm not going to criticize them anymore. So it's up to you to kind of focus or deal with that issue. I will continue to maintain that using euphemisms for child abuse hides the child abuse from view, hides the child abuse from the court's understanding, and hides or prevents our effective treatment of the child abuse. So we should not be using euphemisms for child abuse. The three current euphemisms that are being used: parental alienation, been used for 40 years. Now, more recently, we have resist-refuse dynamic and parent-child contact problems. Those are coming out of the forensic custody evaluators. And so all of those represent euphemisms for child abuse. The actual pathology is a shared delusional or induced persecutory delusion and a factitious attachment pathology. Both of those lead to a diagnosis of child abuse. Those are DSM-5 diagnoses. And so that's what we need to be talking about, is the DSM-5 diagnoses and child abuse, not pathology labels made up, pathology labels. But that's more broad. The fundamental issue is the forensic custody evaluations. Those need to stop. They are really bad things, and that it's the forensic custody evaluation industry that is captured the parents and children, and that's the one that needs to be revised. All this argument about these made-up pathology labels is just noise. We need to go back to the DSM-5. So, but before I leave that domain, I would just want to point out the relevant exhibits that people can look at and make their own determination. First is Exhibit 3. These are 2013 emails from Dr. Burnett, where he, to his parental alienation study group, of which I was a member at the time, in which he indicates that parental alienation is not in the DSM-5, and then he goes to list the DSM-5 diagnoses that it is: delusional disorder, factitious disorder, and child psychological abuse. So we need to be relying on the DSM-5 situation. Then Exhibit 22 is Claude's analysis of the harm that's being done since 2013 by continuing to promote these pathology labels rather than relying on the DSM-5. So that's an AI exhibit. I want to just talk about that for a second, because I'm a little happy about getting an AI exhibit into the legal record, an AI analysis. I think that's pretty groundbreaking in and of itself. But I like how AI can support arguments, because everybody fights about everything in the family courts and the legal system. And AI provides a neutral analysis. So upload it to your AI, talk about it, and deal with it. But this is what Claude looks at, and AI sees what it sees and says what it sees. And so that's the prompt response log for that analysis. And then Exhibit 4 is some correspondence I had with Dr. Burnett in April of 2022 regarding the concerns with the continued use of parental alienation. And so I emailed him and expressed those concerns and cited to Standard 1.05. And that was, and then a month later, they filed the board complaint against me. And then there's another one I think is relatively or pretty important is Claude's analysis of institutional betrayal and resolution. So with Claude, I did a 3-part, and those are 2 exhibits, so the second and third part of the discussion. And the first part was about forensic custody evaluations. And the third part, I think, is really important because it has to do with the institutional betrayal and institutional betrayal trauma. Um, AI, over 40 years of failed protection, AI estimates for the number of undiagnosed child abuse cases in 40 years run from about 300,000 to 1.5 million cases in the United States of undiagnosed child abuse in the last 40 years. That's phenomenal. I agree with the AI. Every case, every custody case where there's a child rejecting a parent should have been diagnosed as child abuse one way or the other. It's either child abuse by the targeted parent or it's psychological child abuse by the alive parent. It goes one way because that's the only thing that creates a symptom of a child rejecting a parent is child abuse. So if it's not by the targeted parent, it's by the alive parent. But there's been 0 diagnoses of child abuse in 40 years from the forensic custody evaluators. So there's a major scandal there. And we have that number of traumatized children who are now adults and their parents who lost their children. So those are the victims of institutional betrayal trauma. Freud, F-R-E-Y-D, institutional betrayal trauma. And so those are we have a substantial number of now adult children and their parents who are trauma survivors of the family courts. And any resolution we get to the active child abuse that's currently going on in the family courts needs to also acknowledge and do outreach to the survivors who had their lives significantly altered and destroyed by the failed practices of the forensic custody evaluators, their experiment on human subjects. So that's Claude's third analysis there, Exhibit 23, Claude analysis of institutional betrayal. And all of these got admitted into the 3-day hearing. So they're now all on record. And that was my goal in this situation. One of my goals is to get everything documented into the licensing boards because they're the ones who should be protecting. But there's no front door entry into them because they give quasi-judicial immunity to the forensic custody evaluators. So there's no way to notify and get oversight from the licensing boards to the incompetent practices. It's a captured field, regulatory capture, institutional betrayal, and institutional capture by the forensic custody evaluation industry. It needs to stop. We need to get clinical psychology, diagnosis, and treatment back into the family courts. But once that happens, the whole industry collapses. Everybody loses their careers as forensic custody evaluators. So there's a tremendous conflict of interest right now within professional psychology and the controls level within psychology. That's what we're dealing with. Institutional betrayal. That needs to stop. Once that stops, everything solves immediately once we get back to diagnosis and treatment. So going forward, I'll let everybody figure out their own opinions about parental alienation and why we should stop using that and get over to the DSM-5. But where I'm going to be focused on my resurrection into the family courts or my continuation in the family courts will be identifying the issues of institutional betrayal and moving that forward. That's Smith and Freud, American psychological or psychologist article. Then there's also additional articles from that group of interest. One is The Psychology of Judicial Betrayal. That's by Smith, Gomez, and Freud. And then the APA, Institutional Betrayal and Torture. That's relative to, or that's from the Gomez et al., and that's the Freud group in the Journal of Trauma and Dissociation. And so these are up on my consulting website. So if you go to my parent resources section, these articles are right up front because that's the situation. I've said since, I've told everybody since about 2015, you cannot solve the pathology in the family courts for any one family until we solve it for all families. You are all in this together because the problem is not individual to you, it's the institutions around you are not doing their job. They are not protecting your children from child abuse. They are not protecting you from spousal abuse, and they should be. The mental health people have duty to protect. We need to be getting the appropriate information about child abuse to the court so the court understands and the court can then take appropriate action. As long as we are withholding the child abuse information and the pathology information that one of the parents has a major psychiatric disorder, a persecutory delusion that they're producing in the child, as long as the court does not know that, the court cannot take the necessary protective action. The problem is in the psychologists, specifically the forensic custody evaluators, and that whole approach needs to stop. It's an experiment on human subjects without IRB approval, without a risk-benefit analysis, and without protections for a vulnerable population. It needs to stop. And once it does, the whole system's collapse and everything gets kind of crazy. New York Blue Ribbon Commission, the only independent commission ever conducted, or independent review ever conducted of the practice of forensic custody evaluations, found that in some custody cases, because of a lack of evidence or inability of parties to pay for expensive challenges of an evaluation, defective reports can thus escape meaningful scrutiny and are often accepted by the court with potentially disastrous consequences for parents and children. They're talking about the practices of the psychologists are going to have potentially disastrous consequences for you and your children. That should never be. By an 11-9 margin, a majority of commission members favor elimination of forensic custody evaluations entirely, arguing that these reports are biased and harmful to children and lack scientific or legal value. At worst, evaluations can be dangerous, particularly in situations of domestic violence and child abuse. So understand, they're talking about the psychologists being dangerous to their client families, to the children, that what the psychologists are doing is harmful to children. Well, then we should stop the psychologists from doing that, please. The pathology in the family courts is child psychological abuse by a pathological narcissistic borderline parent who's collapsing surrounding the divorce. They are creating a shared delusional disorder and factitious attachment pathology in the child to meet their own needs. We need to diagnose that, the major psychiatric disorder in the parent. We need to diagnose the child abuse. We need to protect the child, and we need to solve the situation. That's diagnosis and treatment. We need to stop this practice of forensic custody evaluations and get back to diagnosis and treatment. The problem currently is that parents cannot get a diagnosis and treatment plan. They cannot get a diagnosis of the problem because the forensic custody evaluators are withholding diagnostic assessments and providing the courts and parents with only their experimental forensic custody evaluation. That needs to stop. We need to stop the forensic custody evaluations. So my next phase, talk about resurrection, I'm going to be doing VITA analysis of with Claude, and I've got organizing some parents to help me get VITAs of the forensic custody evaluators. And then we will do a VITA analysis and take it from there about looking at 2.01 for attachment and for delusional thought disorders. And we'll be putting a little project together, and any parents or people who want to get involved in that, my case manager, Anna, is kind of helping me organize that. We'll be doing a Zoom organizational meeting coming up. Now, last year, I took a course from an AFCC-sponsored course about parent-child contact problems. That course resulted in activation of my 1.04 and 1.05 obligations, and there's a little email exchanges between the instructors and myself talking about that. I notified them of my concerns under 1.04. They responded inadequately, moved it up to 1.05. I contacted the APA Ethics Committee. I contacted the Board of Directors for the AFCC, and I filed board complaints against 6 prominent forensic custody evaluators last year in 2025, based on my concerns on violations of 2.01, 2.04, 9.01, and 3.04. That's a cascade that always happens. Talk about it in other seminars. But last year, 6 prominent forensic custody evaluators, I told the APA Ethics Committee. APA Ethics Committee says we don't talk about stuff until after a board complaint. So, okay, I'll file board complaints, because that's kind of what the instructions are about how to handle the ethical concerns pursuant to 1.04 and 1.05 for me. So this year, I'm currently, just a couple of weeks ago, took another AFCC-sponsored course by 5 prominent forensic custody evaluators on conducting parent-child contact problems, forensic custody evaluations. I'm currently in the process of providing my analysis of that, and my 1.04 is active based on the content. It was 7 days, 14 modules. So based on the content, my 1.04 is active. I believe there may have been an ethical violation by another psychologist of 2.04, 2.01, 9.01, 3.04. So that process is in process. And I don't know what people are going to do in forensic psychology until they address the issues. I've got 1.04, and here are the issues, and I've got a catalog of concerns that are going to be coming out, probably published to Amazon. I'm intending to publish them to Amazon probably early spring, early summer. So we'll just keep moving forward and see what happens with the situation. But relative to the California Board of Psychology, I have now formally discharged my duty to protect. And that's what I wanted to talk about today here, is what I told them. And so you can go up to my website again. These are on the California documents that I have posted the settlement offers that I made to the Board of Psychology. And because they are relevant, I'm documenting something. I'm documenting my duty to protect. And so the first one is 8/25 in August, the mitigating circumstances and my settlement offer. And what I did in that is, again, you have to understand, I'm documenting my duty to protect and discharge of that. Basically sacrificing myself or putting myself in danger. And it ultimately resulted in the sacrifice of my license. But the first 28 pages is where I frame things. And it's really, for your interest, it's really about, I think, page 28, where I discharge my duty to protect and say, this is what needs to happen relative to, we need to stop forensic custody evaluations. We need to remediate content knowledge of the forensic custody evaluators, do a VITA review for 2.01 competence. And so that's my offer for settlement. And then I have 275 pages of appendices, because that's what I do. I document into the record. So I had an opportunity. So I've got 275 pages of appendices documented into the record. Now, then the second one was in December. They reopened settlement negotiations, they adjusted a little bit and offered a new proposal. And I responded again with, no, the settlement needs to be that we need to stop custody evaluations. We need to get competent services into these families. And if you continue with this, you're not accepting my duty to protect, the discharge of my duty to protect, by continuing to seek to sanction me. So then I will have to go to 3A hearing to document into the record everything and discharge my duty to protect through the 3-day hearing. So that's the 1225 settlement offer as an appendix to it that basically talks about what needs to happen in the family courts. But now more what I want to talk about in today's discussion is the Gmail that I wrote to them just recently, discharging my duty to protect and surrounding my surrender of license. So here's what I said. This is from my email to them, and you can look at it. First I described my duty to protect. The pathology in the family courts is undiagnosed and untreated child abuse. I give the DSM-5 diagnosis. A shared induced persecutory delusion, DSM diagnosis, and factitious attachment pathology imposed on the child, DSM-5 diagnosis. And undiagnosed and untreated spousal abuse of the targeted parent by the allied parent, narcissistic borderline dark personality parent, using the child and the child's induced symptoms as a spousal abuse weapon, DSM-5 diagnosis. So first, I've got DSM-5 diagnoses, undiagnosed child abuse and undiagnosed spousal abuse. I have duty to protect obligations. So next, I tell the California board, documented into the record, the pathology in the family courts is undiagnosed child abuse and spousal abuse. So they know that now. I've documented that into the record. The next section I told them is acquiring duty to protect. Upon entry into the family courts in 2010, I immediately incurred a duty to protect regarding two dangerous pathologies, a duty to protect the children from child abuse and a duty to protect the targeted parent from spousal abuse. However, since 2010, I have had nowhere to discharge my duty to protect due to regulatory capture and institutional betrayal by the forensic custody evaluation industry in the family courts. That's Exhibit 10, institutional betrayal, capture and betrayal. So I have told them, duty to protect, duty to protect the targeted parent, regulatory capture, institutional betrayal. When I entered the family courts in 2010, I also immediately incurred 1.05 obligations regarding widespread, universal, ethical violations by the forensic custody evaluators in the family courts, violations to 2.01, 2.04, 9.01, 3.04, 8.01, 5.04, and violations to all three principles of the Belmont Report, autonomy, beneficence, and justice. Oops. So I have told them exactly my 1.045 obligations, that I'm discharging it to them, and I've told them the ethical standards that are of deep professional concern. Fulfilling my 1.05 obligations, the next section, I have twice notified the Ethics Committee of the American Psychological Association, once in 2018, Exhibit 15, petition to the APA, and again in 2025, Exhibit 18, the 2025 APA Ethics Committee notification regarding ethical violations pursuant to my standard 1.05 obligations to notify a National Committee on Professional Ethics. I have twice notified the AFCC, an appropriate institutional authority, of the ethical violations, once in 2017 at their national convention, Exhibit 14, 2017 AFCC PowerPoint slides for competence, and again in 2025 to the AFCC Board of Directors, Exhibit 19, AFCC Board of Directors notification. So I have notified the Ethics Committee of the American Psychological Association. I have notified the AFCC. If you read the standard 1.05, it says you take further action appropriate to the situation, and says Such action might include notification of an appropriate National Committee on Professional Ethics, APA Ethics Committee, notification of appropriate institutional authority, that's the AFCC, and licensing boards. That's what I'm doing. I'm notifying the licensing boards pursuant to my 1.05 obligations. I'm documenting that into the record. They now have my duty to protect. I then inform them of the New York Blue Ribbon Commission in the only review of forensic custody evaluations ever conducted by the New York Blue Ribbon Commission on Forensic Custody Evaluations, 2022, Exhibit 5, New York Blue Ribbon Commission. The practice of forensic custody was found to be dangerous and harmful to children, to lack scientific and legal value, and to produce defective reports leading to potentially disastrous consequences for parents and children. So I've told them that the current practices that they're obligated to protect the citizens of their state, not the professionals, the citizens. And I've informed them that the practices of the psychologists in the family courts have been found to be dangerous, harmful to children, lack scientific and legal value, to produce defective reports leading to potentially disastrous consequences for the children and parents who they are obligated to protect. The estimates of the undiagnosed child abuse, I informed them that estimates are that nationally approximately 7,500 to 15,000 new cases of undiagnosed child abuse and spousal abuse enter the family courts every year. And I've written a blog, you can look at it, it's AI analysis. You can do the same analysis with your AI to get your own estimates. AI estimates somewhere between 300,000 and 1.5 million undiagnosed cases of child abuse in the last 40 years, and estimates that in the United States, it's about 7,500 to 15,000, give or take, new cases every year. Now, Europe has an equal number. Europe, Australia, Canada would be an equal number of those. And then we expand out. We got 2 children and families, multiple children, and you consider the parents as well as victims. So you can do the estimates based on how many cases are in the family courts. California is a high population state, and a large proportion of these cases are in California. And I would estimate about 1,000 new cases of undiagnosed child abuse and spousal abuse entering the California family courts every year. So I've told them how many cases we're looking at of undiagnosed child abuse that activate duty to protect obligations. Then I discharge my duty. With my exhibits and testimony during the previous 3-day hearing, case number, there it is, and you can go get the documents from it. I've still got to get the transcripts. I'll get the transcripts and post the transcripts. I have formally discharged my duty to protect the children and their parents in the family courts to the California Board of Psychology, an appropriate protective institution for the citizens of California, and through the California Board of Psychology more broadly to the Association of State and Provincial Psychology Boards, the ASPPB, representing appropriate protective institutions nationally. So there it is. I've discharged my duty to protect. I've held that for 15 years. The moment I hit the family courts, I recognize child abuse and I recognize the spousal abuse. And I've had duty to protect and no place to discharge it. I've notified the APA Ethics Committee, 2018, again in 2025, stonewall. I've notified the AFCC, stonewall. I've now notified the licensing boards, who are the appropriate protective authority. We need to stop the forensic custody evaluation industry. We need to get diagnosis and treatment of the child abuse, not parental alienation, not resist-refuse dynamic, not parent-child contact problems. Diagnosis of the child abuse in the family courts, back into the family courts, so we can take the appropriate protective action to protect the child from child abuse. That needs to happen. We need to at least open the discussion about that, about the delusional disorder and what we're doing about it. And are we competent? Are the mental health people competent in conducting competent assessments. No, they're not. The moment they do open the discussion, the whole situation changes and we begin to protect the children and their parents. So this is solvable immediately the moment anybody wants to solve it. Nobody wants to solve it. So I have formally discharged my duty to protect to them and through them the ASPPB nationally. So because this is a national problem, the problem is institutional betrayal and regulatory capture. And so that's across the United States and internationally as well. And it is what it is. You can read the articles by Freud and her group about institutional betrayal, judicial betrayal, institutional betrayal by the APA, different contexts, but it all comes together in the family courts. Massive scandal. They never should have gone off away and invented new experiments on human subjects. Then I present the California board with the recommendations. Based on 15 years of direct experience in the family courts, I recommend the following: immediate moratorium on forensic custody evaluations, an immediate end to the practice of forensic custody evaluations, parenting plan assessments, pending review by an institutional review board, a risk-benefit analysis, and protections implemented for a vulnerable population of parents and children in the family courts. I tell them immediate into the custody evaluations, risk-benefit analysis, and protections. That's what needs to happen. It needs to happen. And until it happens, we're in a situation of regulatory capture and institutional betrayal because they are not protecting the citizens. They are not protecting the children and the parents. They are protecting the incompetent professionals. Recommendations: content remediation for court-involved psychologists, a structured program of content remediation in 1, attachment pathology, 2, delusional thought disorders, 3, personality disorder pathology, specifically narcissistic borderline DART, 4, child abuse and complex trauma, 5, factitious pathology imposed on children, 6, family systems pathology to ensure compliance with standards 2.01 and 2.04 of the APA Ethics Code. We need to substantially improve the quality of mental health services being provided to the children and the parents and the courts. It is disgraceful the low level of professional practices we are providing to the courts in their monumental high risk decision making that the court has to do, and to the parents and to their children who are in situations of child abuse and spousal abuse. We need to increase the quality substantially in multiple areas of professional knowledge. Recommendations: VITA review. Proactively request the VITA of court-involved psychologists identified through the court lists and other sources for a standardized AI VITA review for 1, standard 2.01 competence in attachment pathology and standard 2.2, standard 2.01 competence in diagnostic assessment of delusional thought disorders based on their education, training, and experience. Now, I do that. That's what I'm doing with my owls, okay? We're going to locate VITAs. We're going to put them through an AI analysis and look and see what we do. Why are the parents doing this? Why isn't the licensing board just going out and request the VITA? Piece of cake. Just request the VITA from the court lists, from everybody who's working in the courts. Get your psychologists who are working in the courts, ask for their VITA. You've got ChatGPT, Claude, Grok, and Gemini. Put them together, use them individually, all to combined. You can come up with a VITA review of the professional VITA looking for competence in attachment and competence in the delusional thought disorders based on their education, training, and experience. And then send them out a letter and say, you know what, we're not seeing it. Can you explain to me where you're competent in attachment and delusional thought disorders? The state licensing boards have an obligation to protect the parents and children in their states from incompetent mental health professionals. Are they incompetent? They give them quasi-judicial immunity. They should then do some proactive steps. If you're not going to review after the fact, you should at least make some effort to ensure ahead of time, proactively, that you got competent mental health services that are being provided. If you're not going to look at what they do, I look at what they do. I get sent them. I'm a second opinion review. I get to read them through the authority of the court system in their challenge of evidence. I know exactly what these forensic custody evaluators do. I've got a catalog of concerns, about 20 concerns. You're going to see those concerns. They are awful, awful, awful things. I agree with the Blue Ribbon Commission 100%. We should entirely eliminate forensic custody evaluations, parenting plan assessments, get rid of them entirely. Dangerous, harmful to children, lack science. I agree 100%. I read them. New York Blue Ribbon Commission does a review. That's what they recommend. Licensing boards are responsible for protecting the citizens of their state. I've now informed them exactly what's going on with recommendations about what needs to happen. Okay, that there needs to be an AI augmented review of the forensic custody evaluations. And then finally, there needs to be outreach to the survivors of the institutional betrayal trauma. The resolution for institutional betrayal trauma, Freud, is institutional acknowledgement of the betrayal when the ones who should protect don't, and institutional courage. And Freud has a Center for Institutional Courage, and there's a website on that. People should be familiarizing yourselves with institutional courage and the treatment for institutional betrayal. The judicial betrayal article by Gomez and the Freud group explains that clearly, because it has to do with a sex abuse case where the child was abused and then the judiciary, for various reasons, did not protect the child. And that child grew up to be an adult with complex trauma from the institutional betrayal trauma and what happened to her by the institutions. When a later district attorney looked at the case and reversed everything and cleared up and apologized for what happened before, and apologized to the victim and said, we messed up before, we're sorry, all that victim's symptoms went away. All their flashbacks and stuff, all their PTSD symptoms disappeared once the institution acknowledged its betrayal. And that's what needs to happen. That's the treatment for institutional betrayal, is institutional courage. The institution steps up and says, we messed up. Now the children who are the survivors of these family conflicts can resolve and understand what happened to them and can get a grasp on what happened to them, because they're no longer blaming themselves, or they're recognizing it was the institutions that should have protected them didn't protect them. It's not your fault. It's not the fault of the parents even. And the parents who lost their children can have their reality restored. You did nothing wrong. The institutions that should have protected you, should have protected your children, should have protected your life and love, failed you. And so they can now get completion to their trauma and resolve and move forward. So we cannot resolve the pathology in the family courts until we also acknowledge the institutional betrayal and institutional betrayal trauma that's occurred over the last 40 years. So we need an outreach program to the child survivors, now adult child survivors, and their parents for the institutional betrayal trauma. So in 2010, I acquired a duty to protect the children and parents in the family courts from child abuse and spousal abuse of the targeted parent. I never left you. In 14 years, you can look at my vita, I'm not from the family courts, but I stayed with the parents and children in the family courts in a context of institutional capture, institutional betrayal, and regulatory capture. In 2026, now this year, yay, I have discharged my duty to protect to the California Board of Psychology and ASPPB, who represent appropriate protective institutions. I no longer need to carry that. So you're on your own in terms of protecting yourselves, okay? I'm going to remain in the family courts. I'm going to continue to do second opinion document review, AI augmented document review. I will continue to try to protect the children and parents through, like, notifying the AFCC instructors, notifying the licensing boards about, competence concerns pursuant to my obligations, 1.05 obligations. But duty to protect is now with them, and that has implications, I suspect, for possible class action lawsuits. Now, I'm a psychologist, not an attorney, but that's going to be a different domain. But that Claude Exhibit 23, I think, on institutional betrayal, Claude we talk about possible class action, and from where I sit, that's likely what it's going to take because of the capture. There's no. This is a special class of people who are isolated out from standard clinical services, and they're being experimented on, and they've captured the institutions. So, and it's harmful, and they know it's harmful, but they're not doing it. So I don't know what else to do other than the next phase would be regulatory, legislator oversight by the state legislators of the licensing boards. Why aren't they protecting the citizens from this forensic custody value? That's one appropriate place to go, is your state legislators. The other is the legal system, a class action lawsuit that I can see based on that. The third would be media, major media, and get their focus over here. Why are these bad things happening or being allowed to happen to these parents and children in the family courts, incompetent mental health services? We need to stop it, pure and simple. The moment we apply the DSM-5, diagnose the delusional disorder, diagnose the child abuse, diagnose the spousal abuse, protect the parent, protect the child, put it on a treatment plan, fix it, solve it. On my estimate, we could solve the individual cases, these cases of child abuse and spousal abuse, in about 6 to 12 weeks. 6 to 12 weeks, all done, all solved, off an appropriate diagnosis of child abuse. But unless we diagnose the child abuse, there's no therapy for child abuse that's going to be effective if we're sending the kid home to the abusive parent. The treatment for child abuse is first to protect the child. Child abuse, protect the child. Then we go to the treatment plan. That's called a safety plan. First, the safety plan, protect the child. Then we go to treatment, solve the problem. We work with the abusive parent, solve it, or resolve it with the child. There's ways to do that. So with that, I'm going to end my Easter sermon, going back to betrayal and sacrifice and resurrection. So the betrayal that we're looking at is the institutional betrayal, the betrayal of the parents and children in the family courts by the institutions and the people who are supposed to protect them. Institutions are made up of people. So there are individual people who have duty to protect obligations, and they're betraying those for their own financial interests. And so it's the institutional betrayal and the sacrifice of the children. Hundreds of thousands of children, they're being sacrificed. And 15, 20, 5,000 a year are being sacrificed to the child abuse in order for these psychologists to be, do what they do, these dangerous things that they do, and financially exploit the families. The resurrection, at some point, the institutions are going to collapse, and we're going to get diagnosis and treatment back. And the moment that happens, that's an acknowledgement that they were experimented on and failed for 40 years. And so that's going to take some institutional courage. But the moment that courage happens, there's going to be a bumpy time. There's no competence in the family courts, and we'll get through that, but we'll get the diagnosis into the family courts. So with that, I'm going to head off to the rest of my Easter Sunday, and good luck to people out there.